Okay, moving right along, we're going to go ahead and move on to Cybernator. And we have an excellent attorney coming up. And Kate is an associate at McDonald Hopkins and a member of the National Data Privacy and Cybersecurity team. So Kate, I just wanted, since you have that long title, does that mean, is that respectful of your income or whatever else? You know, since you probably, you know, majority of lawyers maybe $250, $300 an hour, you're probably at 500, you know, because of the title. But anyway, she has experience advising and coaching a variety of businesses such as health systems, professional service firms, and educational institutions on data privacy and cybersecurity matters, including responding to government inquiries and investigations, and obligations with respect to the state privacy laws, HIPAA, I'll just give the acronym because I don't get it, GLBA and FERPA. And if you know all those acronyms and what they stand for, if not, ask Kate about it, okay? Thank you, Kate.
Thanks, Steve.
Okay.
All right, hi everyone, good to be with you today. I'm going to go over the current and pending cybersecurity laws. So to kick us off, we're going to start with the current data privacy statutes, legal requirements that you should be concerned about in the event of a breach. First, I want to talk about what data must be protected. I know this may seem silly, but oftentimes companies don't know what kind of information we're concerned about, what kind of information is going to trigger a breach, and that is PII, which stands for personally identifiable information. And you'll hear me say PII a lot through the presentation. So the reason we're concerned about PII is because if it falls into the wrong hands, it's going to trigger an organization's obligation to issue notice under state law and potentially under contractual agreements as well. So PII consists of everything you see here on the screen, your name, first name, last name, or first initial and last name in combination with a social security number, driver's license number, credit debit card number, passport information, bank account information, date of birth, medical information, and the list goes on. So it's really important for organizations to know, first, is this the type of information they're collecting? And if it is, where is it being stored? So what system is it on? Is it an encrypted system? Are employees receiving this via email? Are they sending this via email? Is it being sent password protected? All of this is really important because in the event of an incident, these are questions that the legal team is going to ask you. We're going to ask you, what kind of personal information do you have on your systems? Is it a lot? How many individuals do you have personal information on? Is it for all of your employees? Where is it stored? How is it protected? Payment card information also is PII, as you could have seen on the last slide, but it also has additional factors to it that's important for merchants. So if you are processing payment information for e-commerce websites, you want to be concerned with primary account numbers, cardholder name, expiration date, service code, and a PIN code. So this is really important. Merchants that have some type of incident, they still will have a notification obligation if this information is in fact compromised in the event of a breach, and they also will have to loop in special investigations that will involve credit cards, so American Express, Discover, Visa, you name it. So moving on to what is a data breach, before I get into the actual definition under state law, I just want to say this, and you'll hear me say it a few times today, that a data breach is an actual legal term. It carries legal significance. So you want to be very careful not to say the word breach on day one. You want to refer to it as an incident, a cybersecurity incident, data security incident, technical incident, whatever you want to say, but don't say the word breach. You want to only refer to it as a breach when we as your legal team tells you that it is in fact a breach. And oftentimes from day one, that's information you're not going to have. If you go to work, you open up your computer, it's locked down with ransomware, you have an incident, you have a ransomware attack, but you may not have a breach. We may find out 2-3 weeks down the road, 2-3 months down the road that you have a breach, but on day one, you don't know that just yet. And that is because a data breach includes the unauthorized acquisition, access, or use of personally identifiable information. So all the PII we just discussed on the last 2 slides. That PII has to be unencrypted, and it also has to compromise the security, confidentiality, or integrity of that personal information. And again, this is unauthorized acquisition, so it would not include a good faith acquisition of this information. So what does that mean? Plainly, it just means when the wrong person gets the personal information, and they're probably going to do something bad with it, right? That is when we have a data breach. So when you show up to work and you realize you sent out 15 spam emails yesterday, or you show up to work and you realize your system's encrypted with ransomware, at that point in time, you do not know whether or not personal information fell into the wrong hands. It takes some investigation, it takes some time to figure that out. So the first thing you're going to do when you suspect a data breach is call legal. Call insurance if you have insurance. That can be call number one. Second, call legal, because every conversation after that should be privileged. You want to make sure you have counsel on the phone. You want to make sure those conversations are privileged. So while we're learning about what's going on through the forensic investigation, while we're figuring out if or if not a breach has occurred, you want to make sure that that information is not going to get out in the event of any litigation. So keeping that information privileged, keeping the findings of forensics privileged is very important. And that is one of the key reasons why you want to get legal involved. The second is, so if you do have a breach, you know what you have to do, right? So there's so many things that go wrong when there is a data breach. You're dealing with potential loss of revenue, your systems being down, you're dealing with a lot of money being spent on the forensic investigation. Well, you also have to deal with, in the event of a breach, your legal obligations. So who you need to notify, how you need to make sure those notifications go out, what attorney generals do you need to notify, whether you should notify the FBI. These are all decisions that we as your legal counsel can assist you with. So to start with some of the state breach laws, I know we went over just the boilerplate version of a data breach, but it gets a bit more nuanced, and that is the risk of harm threshold. So what that means is, for a simple example, if an employee emails their HR team and says, hey, I need my W-2, tax season's coming up, can you send it to me? And HR accidentally sends them every single employee's W-2 form, and it's happened before, it actually happens quite often. Now this one employee may have 300 social security numbers of all of their fellow employees. That may sound like a data breach, and it kind of is, right? An unauthorized person, this employee, now has personal information for individuals that they should not have. And that was not a good faith acquisition. Now the tricky part is does that acquisition really qualify as something that's going to compromise the confidentiality, integrity of that PII? Well, if we can get this employee to agree to delete that information, sign an affidavit saying they didn't send it to anyone, they didn't copy it, they didn't save it, they deleted the email right when they received it and all the information, we may be able to rule out a data breach under a risk of harm threshold. So that risk of harm threshold varies based on whatever state the individuals whose information was breached, where they reside. And we'll get more into that throughout the presentation. So again, circling back on why we should be careful with the word breach, again, it has legal significance. You want to always use the word incident from day one. When we do know there is a breach, there is actually a clock that starts ticking. That clock varies based on the state we're concerned with. Some states have a 30-day clock. If we're talking HIPAA, we have a 60-day clock. So if you start using the word breach from day one, people who hear that may think, okay, so in 30 days, they're going to do this and they're going to do that. But if you don't actually have a breach, you're not going to do those things. So I had a client a couple of months ago, and they were hit with ransomware. They did not have an actual breach yet. We didn't know. We knew they were infected with ransomware, but it was a new variant, and we didn't know a lot about it. We didn't know if this particular ransomware variant would result in the exfiltration of data. So within the first week, some systems were impacted, and this particular company was unable to effectuate payroll. It was going to be late by a few days because they had to issue some live checks. One of the employees went to send an email to another employee to let them know, hey, payroll's going to be late, you'll get it via live check. Well, in that email, they said, hey, we've been breached. You're going to get your paycheck a little bit late, and it's going to be a live paycheck. This employee was very upset that they were going to get their paycheck late, so they sent this memo to the media. And the media posted it, and then the media posted it again, and it just picked up, and it was about a week of a PR nightmare. And it got worse, because the media, they like to do their job, right? They're not just going to say, oh, look at this memo that we got on this company. They're going to look up what a breach means, and that is PII being stolen, right? So they're putting out there PII was stolen. This company was breached. They have to notify regulators. They went one step further, and they FOIA requested the Attorney General to see if we notified them. We did not, because it was not a breach yet. So that was the next headline. They didn't comply with their legal requirements. They didn't notify people. All because one employee sent another employee a memo using the word breach within the first week. So I'm being serious when I say don't use the word breach, because it can turn into a PR nightmare. So moving on to the breach notification laws. as I'd mentioned, you want to take a look at the residents of the individuals who are impacted. So we're in Michigan. A company in Michigan may be breached, right? We have a confirmed breach. What kind of laws are we going to look to? Well, we can start looking at Michigan because it's safe to say if a company is located in Michigan, a lot of their customers, a lot of their employees also are probably located in Michigan. Well, let's say this particular breach took 10 years of data, and we have about 50 employees who now live in Florida, right? Michigan's a big snowbird state, so these retired employees are now in sunny Florida. We have to look at Florida law when we treat those former employees, right? We're no longer looking at Michigan. Although the company may be located in Michigan, those 50 employees now live in Florida. So when we notify the Michigan employees, we'll look to Michigan law, and when we notify the Florida employees, we will look to Florida law. Those laws are different. We'll get into some of those differences, but Florida requires notice in 30 days. Michigan does not. Florida has an attorney general notification requirement if you meet the numerical threshold. Michigan does not. Florida considers medical information, PII. Michigan does not. So if this is the kind of information where it's someone's name and their health insurance information or a medical diagnosis, all those employees in Michigan, they don't need to get notification, right? If we're not talking HIPAA. But those employees that live in Florida, they still will. So it's important to take a look at where individuals live and whether or not the actual PII impacted is considered PII in the state they live. So when we're dealing with large corporations and hundreds of thousands of people, we're the ones that are behind the scenes going line by line, looking at where John Doe lives, what state he lives in, and whether or not the information that was impacted for him is PII, if he needs notice, when does he need notice, when does the Attorney General need notice, and so on. Another thing in the breach notification laws is encryption. So if you have really good safety measures in place, if you have your servers encrypted and they're stolen by a threat actor in a ransomware attack, well, you might be in luck because if it's encrypted and the threat actor can't get into it, the PII is not actually compromised, right? It's taken, but it's encrypted. He can't read it. He or she can't read it. So it has that encryption safe harbor. Similarly, in my previous example with the HR employee who sent everyone's W-2, if they get in the habit of every time we're going to send something with the social security number, we're going to password protect it. Well, maybe after they sent the email and realized, crap, I just sent 300 social security numbers out. Oh, good, it was password protected and I didn't give them the password yet. You're in luck, right? That employee was unable to open up that PDF. So having an encryption safe harbor is really going to come in handy. Having your servers password protected, getting in the habit of sending sensitive information in an encrypted manner is going to save you in the long run. There's a lot of things we send via email that we don't think about, right? And it could be personal to yourself. It could be your kids' information that you're sending to the school. It could be friends' information. You want to be careful that no matter the information, whether it's yours, a family member's, or a customer's, you're making sure it's password protected when you're sending it. So moving on to some more ways that the state laws differ in respect to state breach notification laws. So I had mentioned with Florida, the timeline, right? Florida requires 30 days, Michigan does not. Some are as soon as 14 days. That's specifically for Vermont. The Vermont Attorney General is the only Attorney General that requires a heads-up notice within 14 days. We have some other states that have 30-day notice requirements, then 45 days, and the most common is what Michigan has, and that is effectuating notice within a reasonable time. We like to say reasonable time is at most 60 days after the discovery of a breach, but there's a lot of factors that can go in that can cause delay or make it longer to issue notice. Other ways state laws differ is notification to attorney generals. So whether or not notice is required to an attorney general, if it's required, what you're going to put in that notice. So every state, again, has a different threshold. Indiana, New York, New Jersey, they all require notice to their attorney generals in the event that one resident was impacted in a breach. Then you have other states like California, Texas, Florida, they have a higher threshold, right? 250 or more, 500 or more must be impacted before we want to know as the attorney general. Then you have states like Michigan, Pennsylvania, they don't ever want to know. You never have to notify their attorney general in the event of a breach. That's not to say that they won't carry out an investigation, though. We've had those attorney generals carry out investigations, even though they don't require notice. So kind of interesting. Other ways state laws vary is how long you should keep the records after an incident, after a suspected or actual breach, how you should effectuate substitute notice, which briefly is basically when you don't have everyone's contact information. You can't mail them a letter. You can put things on your website. You can alert the media in a press release. So state laws differ on how exactly to do that. Some recent amendments to the data breach notification laws are some elements added to the definition of PII. So your mother's maiden name is now one, right? That's a common password question. Date of birth for North Dakota and Washington, that is considered personal information. Medical information was newly added recently to a few more states, and marriage certificate. Other amendments decreased time to notify, so having to notify state individuals and state regulators within 30 days instead of 60 days. Requiring notice to state attorney general. So some states are requiring more notice. Arizona came out recently. It's still pending legislation. They want notification to Homeland Security. So things are changing, right? Some states are now requiring credit monitoring in the event of an incident be offered to individuals. So moving to vendor agreements, although this isn't something that's going to be required under state law, you may have agreements with the vendors that you work with, and those agreements may require you to issue notice. So if you're collecting information on behalf of a company and you were hit with an incident and it's determined to be a breach, you may have an obligation to notify this company you have an agreement with and issue notice on their behalf. Similarly, if you're a company and you're giving your information to an MSP, to a cloud service provider, to a billing firm, to someone doing your payroll, and that information was impacted because they have a breach, they have an incident that's determined to be a breach, you as the company that had that data to begin with still have the responsibility to make sure notice goes out in accordance with state law. Now, if you have proper agreements in place ahead of time, you may be able to shift that responsibility and make sure they're the ones that issue the notice, but you as the data owner, at the end of the day, you need to make sure it goes out. You need to make sure that things are done properly under state law, or you're going to be the one that gets in trouble with the states. You may be the one dealing with sanctions, investigations, things like that. Cyber liability insurance, of course, is very important, and I know Highland will talk about that today, but if you are a company, of course, look into getting cyber liability insurance, but if you have an agreement with a vendor and you're providing your data to that vendor, see if you can put in your agreement that they also need cyber liability insurance. That way you know if they have a breach, they have coverage, and they have the ability to get forensics involved, pay to get notice out, pay to get credit monitoring, and pay to get legal counsel. As you know, hearing the word breach is very unsettling, so it, of course, can cause some reputational harm to your company in the event of a breach or in the event there is never a breach, right? The way you message things is very important. You want to be transparent, but at the same time, you don't want to get ahead of yourself and start saying the word breach or saying the word an attacker hacked us when it's day 1 or 2 and you're still trying to figure things out. So just some interesting statistics. 62% said breach notification decreased trust and confidence in the organization. But I do find that the more cyber incidents there are, the more letters people may get in the mail. I think they're becoming a bit more desensitized to the fact that our information is out there, and that one more letter you get in the mail may just be that, one more letter you get in the mail, right? It's not something new anymore. It's always a different reaction that we see on the back end after we effectuate notice and how people react to it. 94% believe that reporting organizations are solely to blame for the breach. Sometimes that's true, right? Sometimes corporations don't have the security in place that they should. Other times, corporations have the best security in place. They have all the bells and whistles, and maybe it took one employee who was scrolling through their email and just not paying attention and clicked on a link, and next thing you know, they're infected with ransomware. So reputational harm is definitely something to be considerate of in the event of an incident, and we always have PR firms on standby to loop in, help with crisis communications, help manage incidents. If it is going to be a type of incident that is going to take off in the media, the PR firms will also monitor the media, give us daily reports every morning, let us know, okay, this was on Channel 4, Channel 7, this report was sent out, this is going out, and the media can be quite ruthless sometimes with these kinds of incidents. So it always varies on what gets picked up, what's hot and what's not, but having PR on standby definitely helps, and that's what we're here for, is to be the liaison and bring them in. So now that we talked about all the scary things, what happens when there's a breach, what do you have to do to comply with the law, here are some, happier notes, what you can do to be proactive to maybe help in the event of a breach, right? So it'd be nice to say you can do X, Y, Z and never, ever, ever have a breach, but it's better to say you can do X, Y, Z and be prepared in the event of a breach, because you always want to be prepared, always assume it's going to happen versus assuming you can, get things in order, and it will never happen. So some of those things are getting a written information security program in place, also called a WISP. The reason that's important is because some state attorney generals, Massachusetts in particular, requires it. So if you have a breach and you have to notify the Massachusetts Attorney General, they will ask you if you have a WISP. If you say no, they will send you a warning letter. So you want to make sure that you have that. You don't want to have some sort of unnecessary investigation in place because you didn't just have, a prepared document in place ready to go. Incident response plan is going to be your best friend, and we'll talk about that as well throughout the presentation. This is going to be your roadmap, your go-to document. What do you do the second you suspect an incident? Carefully drafted confidentiality agreements for your employees, your vendors, and your visitors, making sure people understand the sensitive nature of PII, keeping it confidential. Proper ongoing training of employees is really, really big. Please train your employees, train them to catch phishing emails, train them not to be happy when it comes to links and click on everything they see. Tell them to be aware, take a look at what they're getting. I received an email this morning from some random email account that was purporting to be someone that I knew. So I caught it, I forwarded it to IT, it was fine, but it happens all the time. So you just want to be aware and be on the lookout. Perform your data privacy review, risk assessments, test out your system, make sure it's secure, make sure you have everything in place, and also review your employee exit program, right? We've had issues in the past with clients where they may have terminated an employee, and this employee, real quick, sticks a thumb drive in their system and downloads a bunch of PII to take with them. Granted, they might not want to commit, some sort of identity fraud with it, but they're still taking it with them so they can solicit these people later on. So something you want to think about, you have those measures in place. Incident response team, as I mentioned, this is going to be your best friend, your go-to document. Who do you want on your team? You want the C-level decision makers, so your CIO, the CEO, your chief communications officer, marketing, HR, legal, some forensic companies, IT. You want the whole kit and caboodle, right? You want everyone on the team that's going to know what to do. So from day one, when you're on the phone with us, all the decision makers are already aligned and in place. If we need to figure out, okay, are we paying a ransom? The decision maker is already in the room and on the phone to make that call. If we need to figure out, okay, server A was infected and we see 50 gigabytes of data being taken from there. What's on server A? We have the person in the room who knows what's on that, right? They can tell us, oh, it's nothing we need to be concerned about. It's all internal documents. Or crap, that's all of our employees' W-2 information, right? So having those people in place is going to be really helpful from day one. It saves a lot of time and it just helps the ship sail much more smoothly. Other ways that your incident response team and plan are going to work together is you're going to have the roles of everyone on your team defined throughout the incident response plan. You're going to have decision trees, and you're going to test the plan and test the plan again and again. We do this with our clients all the time. We call them tabletop exercises. You can do them yourself with the company. You want to go through your incident response plan and make sure it works, right? You don't want the first time you're testing out that plan to be when the house is on fire and you're freaking out. You want it to be the second or third time when you've already done it once, right, in an informal setting, a hypothetical setting. It's never going to be fun, right? It's never going to be fun having an incident, but at least you've done it once in a hypothetical scenario, and you're able to feel a bit more comfortable when the real thing happens. What's to come? So the new impending laws in the cybersecurity space. That is the consumer data privacy laws. We're seeing a lot of these come up in 2023. So this is different than data breach notification laws. So different than what we just went over. This deals with the collection and handling of personal information. So the California Consumer Privacy Act is being amended. Virginia's rolling out their version of a consumer data privacy law. So is Connecticut, so is Colorado, and so is Utah. So what exactly are these? These aim at giving consumers more control over their personally identifiable information. It holds businesses accountable. It requires them to adhere to certain data privacy policies and principles when collecting personal information, and it gives consumers specific rights on how their personal information is handled. This isn't going to apply to all businesses in these states. There are certain thresholds. This is mainly focusing on larger businesses, so businesses collecting PII on 100,000 or more individuals, or businesses that make a certain revenue threshold each year. Some other new laws that are coming out is prohibiting ransomware payments. So for state agencies in North Carolina and Florida, this is my last slide.
I just wanted to let you know it's your last slide.
So this is really new, and we can talk about more about this on the panel in a few hours, but North Carolina and Florida came out recently, earlier this year, that if you are a state agency or government agency, you cannot negotiate with criminals to pay a ransom or pay a ransom at all. This has big impact that we can save for the panel, leave you all on a hook for a few hours from now. Pennsylvania and New York are deciding this currently on if this is something they should pass to. So stay tuned for the panel, and we can talk more about this and why it's important. Thanks, everyone.
Thank you, Kay.